Hello and welcome to Courts Today by Live Law. Let's get to today's top legal updates. Can't believe married woman fell for marriage promise. Supreme Court quashes rape case. Delhi High Court to Mohak Mangal. Remove Gunda Raj, Hafta Vasuli from ANI video. Centre notifies 3 new Supreme Court judges. Supreme Court seeks Jharkhand government's reply on woman judge's childcare leave plea. Supreme Court to hear Jamia Nagar demolition challenge next week. In the Bangalore Palace case, Supreme Court orders TDR certificates to be sealed. Bureaucrats arrogant. Avoid high courts. Supreme Court criticizes Jammu and Kashmir administration. Chhattisgarh coal scam. Supreme Court grants interim bail to key accused. I am your host, Syed Amir Hussain, with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelaw.in. Please make sure to watch this video till the very end and don't forget to like, share and subscribe to our channel because your support means the world to us. Live Law Premium subscription starts at just Rs 1099 plus GST. Subscribe now. The Supreme Court recently ruled that consensual relationships should not be turned into criminal cases of rape based on false promises of marriage, especially when the promise itself is legally invalid. The case involved a woman already married and with a child who accused a 25-year-old student of rape after their year-long consensual relationship ended. She claimed he had promised to marry her, but the court pointed out that since she was legally still married, such a promise had no legal value and was unenforceable from the start. The court observed that there was no evidence of deceit or fraud and that both parties willingly stayed together and travelled, showing mutual consent. It stressed that every failed relationship cannot be treated as rape unless there is proof of intentional deception. The FIR, which included serious charges like rape and unnatural sex, was quashed. The judgment strongly criticized the misuse of criminal law in personal disputes and warned that false accusations can destroy lives. It reaffirmed that the law is meant to deliver justice, not to be weaponized to settle personal scores in intimate relationships. The Delhi High Court on May 29 heard ANI's defamation suit against YouTuber Mohak Mangal over his viral video titled Dear ANI, which has over 5.5 million views. ANI alleges the video is defamatory, calls it a media campaign to damage its reputation, and accuses Mangal of misrepresenting communications using AI tools and violating copyright by using ANI's video clips without permission. Senior advocate Amit Sibbal for ANI argued that Mangal's language, calling ANI a gunda and urging viewers to unsubscribe, is offensive, damaging and monetized. He added that Mangal refused to take a license for using ANI's copyrighted content and accused the agency of extortion for demanding Rs 40 lakh annually. The court, after watching parts of the video, said words like Hafta Vasuli and Gunda Raj were offensive and asked Mangal's lawyer, senior advocate Chandar Lal, to consider removing them. Lal argued that ANI has no licensing rights and that fair criticism is legal, but agreed to provide a redacted version. The court emphasized its current concern was defamation, not copyright, and questioned Mangal's justification for such strong language. The central government has appointed 3 High Court judges to the Supreme Court, bringing the court back to its full sanctioned strength of 34 judges. The newly elevated judges are: the first, Justice NV Anjaria, currently Chief Justice of the Karnataka High Court and originally from the Gujarat High Court. Justice Vijay Bishnoi, Chief Justice of the Guwahati High Court and originally from the Rajasthan High Court. And Justice A.S. Chandurkar, a judge from the Bombay High Court. The announcement was made by Union Law Minister Arjun Ram Meghwal on social media, confirming that the President of India has approved the appointments after consultation with the Chief Justice of India, B.R. Gavai. The Supreme Court Collegium had recommended their elevation on May 26th. These appointments fill existing vacancies and restore the Supreme Court's full strength. However, another vacancy will arise soon with the upcoming retirement of Justice Bela M. Trivedi on June 9th. Following that, Justice Sudhanshu Dhulia will retire on August 9th, and CJI BR Gavai is set to retire on November 23rd. On May 29th, the Supreme Court issued a notice to the state of Jharkhand and the Jharkhand High Court on a plea filed by a woman additional district judge challenging the rejection of her childcare leave. The judge, a single parent from the scheduled caste category, had sought 6 months leave from June to December, which was denied without any explanation. The bench of Chief Justice of India B.R. Gavai and Justice A.G. Masih asked why the petitioner did not first approach the High Court. Her counsel explained that since the High Court is on vacation, the matter may not have been treated as urgent. The lawyer further stated that the petitioner had disposed of 4,660 cases in just 2.5 years and deserved her leave under the childcare leave rules, which permit her up to 730 days of leave. She is currently only seeking 6 months. The court directed that notices be served immediately and added that the petition may be decided finally at the earliest possible date. The case will be heard next week. The CJI stressed the urgency, stating, "Serve the notice immediately today." The Supreme Court on May 29th agreed to hear next week an application challenging demolition notices issued to residents of Batla House, Jamia Nagar, Delhi. The application was filed by 40 people claiming to be genuine residents and owners of properties located in Khasra numbers 271 and 279. Their lawyer mentioned the matter before CJI BR Gavai, seeking urgent listing. Initially, the CJI asked the applicants to approach the High Court. However, the counsel argued that the demolition notices were issued in violation of a previous Supreme Court order, which require proper notice and procedure. The lawyer claimed that notices were suddenly pasted outside their homes on May 26th without any prior hearing. He clarified that the original order was related to a private land dispute that was converted into a contempt case and does not apply to them, as their homes fall outside the area in question. The applicants also said they have valid documents and proof of possession since before 2014. After reviewing the documents and hearing the arguments, the CJI agreed to list the matter for hearing next week. The Supreme Court on May 29th ordered that the transferable development rights certificates issued in relation to the acquisition of 15 acres of Bangalore Palace grounds must remain with the court's registry for now. If any TDRs have already been handed over to the Mysuru royal family's heirs, they cannot be sold or used until further orders. This interim order aims to protect the interests of both the Karnataka government and the royal family. A 3-judge bench of Justices Suryakant, Dipankar Datta and N. Koteswar Singh also directed that the matter will be heard in detail by a larger bench starting the week of August 18th. The court said the 2014 order, which led to the current situation, may have involved a bona fide error due to inadequate assistance from the state's side. The legal dispute began in 1996 with the acquisition of the palace grounds under the state law. The royal family challenged it in 1997 and the case has been pending since then. The Karnataka government recently questioned a May 22nd order that directed it to release TDRs worth over 3,000 crore rupees. The matter will now be reviewed fully. The Supreme Court on May 29th pulled up the Jammu and Kashmir administration for not responding properly to a contempt notice issued by the J&K and L High Court. The case relates to non-payment for a plant supply contract where the High Court had directed the administration to clear dues within 2 months. When the payment was not made, the contractors filed a contempt petition and the High Court issued a show cause notice to the involved officers. Instead of appearing before the single judge and explaining whether payment was made or not due, the administration filed an intra-court appeal, which was dismissed. They then moved the Supreme Court. A bench of Justices Suryakant and Dipankar Datta said the administration should have responded directly to the High Court. Justice Kant noted, sometimes bureaucrats have arrogance. They don't want to go before high courts. The court said show cause notices are standard and do not imply guilt. It directed the officers to explain their position before the single judge, who will then decide the matter as per the law. The court refused to interfere further and clarified the High Court will handle the issue appropriately. The Supreme Court on May 30th granted interim bail to several accused in the Chhattisgarh coal levy and DMF scam cases, including Suryakant Tiwari, Soumya Chaurasia, Ranu Sahu and Sameer Bishnoi. A bench of Justices Suryakant and Dipankar Datta ordered that they be released on bail until further notice, subject to certain conditions. One major condition is that these four accused cannot stay in Chhattisgarh, except when they are required to appear before the investigation agency or the trial court. The court said that this was necessary as these individuals had the potential to influence the investigation. They must provide their residential addresses outside Chhattisgarh within 1 week of their release and deposit their passports with the special court. The court warned that if any accused tries to influence witnesses or tamper with evidence, the bail will be considered misused. Justice Kant stressed the need to protect witnesses so they feel safe to speak the truth. This bail applies to all listed cases, including the DMF scam, and does not affect the prosecution's arguments or future decisions in the matter.